When changes are made, the question always arises, reform or stand still? Do you wish to take a step forward and benefit from a modern, more flexible inheritance law? You are given more freedom opportunities to distribute your assets according to your wishes. What exactly do you have to do? Would you like the peace of mind of having your final affairs taken care of? That's what this video is about. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If you like this video, then forward it to someone else. What is the objective of the modern law of succession? The purpose is to give the testator more freedom to distribute his assets, to devise his property. How is this achieved? The statutory share of the descendants is reduced and the compulsory portion of the parents is abolished. This automatically increases the available quota. The free quota is, as from January 1st, 2023 on, always at least half of your estate, regardless of your family situation. This allows a testator to favor persons of his choice significantly more, for example, individual heirs, cohabitation partners, stepchildren, foster children, best friends, or charitable institutions. In other words, a testator may devise a larger part of his estate to desired persons, or a testator may simply change the statutory proportional rights and inheritance by testamentary disposition. Think of your estate like a cake. You can determine who will receive a large or a small piece of the cake, or who must do without. You may exclude siblings and parents from the legal right of succession. Issueless spouses are often convinced that the surviving spouse will inherit everything. This is a misconception. Without your active estate planning, your surviving spouse must share with your parents. It's up to you to appoint them as sole heirs in your will. A testamentary disposition is mandatory. Otherwise, the surviving spouse will receive only 3/4 of the estate, and your parents remain legal heirs. If you have children, you may treat them unequally for valid reasons, or favor an outside third party, such as a life partner. Cohabitation partners and blended families are real relationships, without kinship status and without legal hereditary rights. If the testator does nothing, these partners and stepchildren will be left empty-handed. However, a testator is not obliged to do so. Nonetheless, there may be an emotional responsibility to protect your loved ones. It's up to you alone to make use of your freedom, your option, and your responsibility. Without your active action, the legislator provides for a regulation. Legal succession applies if you die intestate. The legislator links to legal status relationships, such as marriage. If this does not suit you because you prefer de facto relationships or a charitable institution, you have to actively plan your estate. Especially single people and childless widowed spouses may wish to support someone or something to leave relatives empty-handed. You have the choice whether to make a holographic will, for example. With the will, your last wish should be carried out. You can appoint a favored person as your heir, or to bequeath something to someone special. If circumstances change, a testator can revoke or amend his will at any time. Please write down what you want to accomplish with your estate plan. Act now. Don't put off estate planning. You will feel liberated when everything is settled. I look forward to supporting you, fulfilling your personal and last wishes, to have a peaceful distribution of your assets. Contact me for a consultation.